It's Thursday, May 28th, 2020. And 3 days ago, I received a text from Jack Pink, who's the agent for the owners of this property. Jack says, "Hi Jeff, I need to access the property. I have someone that needs to inspect something on the outside of the property." I replied, "When and what areas are to be accessed, please?" Jack says, "I'm not sure. I think TSSA needs to look at propane tank or something to do with hydro. I think in about 20 to 30 minutes." I reply, "Okay, no problem." Jack asks, "Will someone open the gate for them? How about the dogs? Will you take them in?" I replied, "I will look after the dogs and open the gate." Jack says, "Okay, the guy is there. Can you please come and open the gate? Anime is welcome to accompany him if he wants." I say, "Okay." So I went to the gate to open the gate. I saw an individual in a vehicle. I went over to the vehicle and he handed me these envelopes and said, "You are served." We waited the 3 days to check the contents of these envelopes. Our life has been particularly hectic and demanding for the last few weeks. We've had to deal with things that are not normal and were very upsetting and also took up a lot of our time. And now we're going to open these and see what's inside. And the winner is court file number, Ontario Superior Court of Justice, electronically issued between plaintiff 385277 Ontario Limited and Jeffrey Gold and Anime Gold, defendants. Statement of claim to the defendants. Legal proceeding has been commenced against you by the plaintiff, and so on, within 20 days. If you fail to defend this proceeding, judgment may be given against you in your absence and without further notice to you. If you pay the defendant's claim and $1,000 plus GST for costs within the time for serving and filing your statement of defense, you may move to have this proceeding dismissed by the court. If you believe the amount claimed for costs is excessive, you may pay the plaintiff's claim and $100 for costs and have the costs assessed by the court. Take notice that this action will automatically be dismissed if it has not been set down for trial or terminated by any means within 5 years after the action was commenced, unless otherwise ordered by the court. The proceeding is brought against you under the simplified procedure provided in Rule 76 of the Rules of Civil Procedure. Claim. The plaintiff claims damages in the sum of $67,500 for breach of contract. In the alternative, damages in the sum of $65,000 on the principle of unjust enrichment. In the further alternative, damages in the sum of $65,000 on the principle of quantum meruit. Pre-judgment and post-judgment interest at the rate of 1% per month in accordance with the invoices as defined hereunder. In the alternative, pre-judgment and post-judgment interest in accordance with the rates prescribed by the Courts of Justice Act, RSO 1990. Costs of this proceeding on a substantial indemnity basis plus HST and such further and other relief as this honorable court deems just. The plaintiff is a company incorporated pursuant to the laws of Ontario. The defendants are husband and wife and are renters of the property. The plaintiff states that on or about June 10th, 2019, it entered into a written lease with the defendants to rent the property for a period of 24 months. Late 2019, early 2020, the plaintiff was approached by the defendants who asked if they could be released from the balance of their term and asked if they could vacate the premises on or about April 30th, 2020. After some discussion, the plaintiff agreed that provided that the defendants vacate by that date, it would be prepared to permit the defendants to terminate the lease without further obligations under the lease on the conditions that they vacate the premises by April 30th, 2020. In accordance with such agreement, the plaintiff received a tenant's notice to end tenancy from the defendants that was signed on February 27th, 2020. The notice provided that the tenancy would terminate on April 30th, 2020, and that the defendants would move out of the unit on or before the termination date. The plaintiff states that despite the defendants coming to such obligation, they did nothing to secure alternative premises, and despite the commitment as set out above, they did not vacate the premises on April 30th. In addition, the defendants put a stop payment on both their April 1st and May 1st post-dated checks, each in the amount of $4,500. As a result of the breach of the defendants, the plaintiff is entitled to damages for the rent for the balance of the term, which is 15 payments times $4,500, or $67,500. The plaintiff also states that the defendants have provided a security deposit of $4,500, which will be applied to any damages to the premises or alternatively rent once the plaintiff can assess the property after it secures possession. The plaintiff asks that this matter be tried at Toronto. Miller Thompson, barristers and solicitors. Kevin D. Shirkin, lawyers for the plaintiff.
So who did they say asked to terminate?
The claim is the plaintiff was approached by the defendants who asked if they could be released from the balance of their term and asked if they could vacate the premises. Now, actually, we have an email from the owner via his agent, Jack Pink, where he offered to let us out of the lease if we were unhappy. That was back in, I believe, November 2019. We responded by saying we acknowledged that offer, but for the time being, we thought there still might be a possibility that we could come to a new agreement that would honor everyone concerned and our concerns, and that we could move forward under a new agreement. So in this statement of claim, the owner of the property makes certain allegations which we believe can be easily refuted, and conveniently leaves out a number of facts which we believe are important in our defense against this claim, and therefore we will send this to our lawyer for his consideration and response.
Are you concerned?
No.